This is Barry Zalma speaking for Claim School Incorporated's blogs, Alma on Insurance. Today we're going to speak about a RICO suit against chiropractors brought by several Allstate insurance companies to effectively allege a RICO conspiracy charge against several chiropractors and people providing equipment for the practice of chiropractic. In Allstate Insurance Company versus Lint Chiropractic et al., a May 30, 2024 decision of the United States District Court for the Eastern District of Michigan, Allstate brought a RICO case against chiropractors and conspiracies to defraud Allstate. Various Allstate insurers accused several medical and chiropractic clinics, their suppliers, and their managers of orchestrating a racketeering scheme to exploit Michigan's no-fault insurance law by generating and submitting hundreds of fraudulent medical bills for reimbursement. In response to dueling motions for summary judgment, the United States District Court concluded that the plaintiffs, Allstate, have sufficiently alleged their claims, but that the defendants' counterclaims for declaratory relief fell short of proving a factual or legal basis distinct from the original allegations, and therefore defendants' motion to dismiss was denied, and plaintiffs' motion to dismiss was granted. Robert Supra, a chiropractor from Florida, exercises dominion and control over all units of a medical device called a nervomatrix. The nervomatrix is used to treat trigger points, painful areas of knotting or tightness in muscles, and to do so the nervomatrix first scans for trigger points and then treats them with electrical stimulation. Super proliferated the fraudulent use of Nervomax machines at numerous medical clinics in Michigan, as Super implemented a predetermined protocol mandating the use of Nervomatrix machines regardless of medical necessity. Defendants also billed for services not rendered with the Lint Chiropractic, billing for treatments at some clinics before Nervomatrix machines were installed there, and Super billing during times that those clinics considered the machines abandoned because they had lost contact with him. Lint Chiropractic frequently used pre-printed prescription forms with identical signatures altering only the date and clinic address. Plaintiffs allege that violations of two provisions of the RICO statutes, and plaintiff have plausibly alleged claims under both provisions. A RICO enterprise may include any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated, in fact, although not a legal entity. This definition is intentionally broad, designed to stamp out corruption. Liability under U.S.C. Section 1962C requires that defendants participate in the enterprise's scheme. The participants in the scheme alleged by Allstate started with Lint Chiropractic Enterprise, owned and managed by Super, and who directed its staff's conduct. He installed Nervomatrix machines there and developed a predetermined protocol to direct patients toward unnecessary treatments resulting in fraudulent billings. Then there was MI Medical Enterprise. Super also owned and managed MI Medical, implementing the same fraudulent protocol used at Lint Chiropractic. Diagnostic conducted unnecessary tests on MI Medical patients to support these bills. Next was Supplies Plus Enterprise. Super managed supplies plus deciding to write prescriptions for unnecessary DME and generating fraudulent bills. And finally, there was Diagnostic Chiropractic Enterprise, also managed by Super, which billed for unnecessary tests arranged by Lint Chiropractic. The USDC concluded that plaintiffs sufficiently alleged the existence of each enterprise and how defendants participated in the conduct of those enterprises. To establish a pattern of racketeering activity, plaintiffs needed to demonstrate that the defendants committed at least 2 predicate acts of racketeering within 10 years. Plaintiffs alleged that all the predicate acts of mail and wire fraud served the common purpose of inducing plaintiffs to pay large sums for bogus medical bills. These allegations sufficiently demonstrated the necessary relationship among the acts. Although fraud claims are subject to a heightened pleading standard requiring the plaintiffs to state with particularity the circumstances constituting fraud or mistake, the Allstate plaintiffs adequately alleged the fraudulent scheme, detailing how the defendants orchestrated a plan to defraud plaintiffs with the nervomatrix and fraudulent medical bills. Plaintiffs have pled their Section 1962 C fraud claims with sufficient particularity under Rule 9b, and the defendant's motion to dismiss on those grounds was denied. Then there was the RICO conspiracy under Section 1962 D. The key is not that each defendant committed every act of fraud, but that they conspired to achieve the fraudulent objectives of the enterprise, and that was sufficiently alleged. If plaintiffs prevail on their fraud claims, the USDC noted that it will be unnecessarily mean that counterclaimants are not entitled to the plaintiffs. Thus, the counterclaims serve no purpose. Accordingly, the defendant's motion to dismiss was denied, and it was ordered the plaintiff's motion to dismiss was granted. In my opinion, the type of fraud that Allstate used to base its RICO action is rampant, as detailed in the hundreds, if not thousands, of health insurance fraud convictions reported in Zelma's insurance fraud letter twice a month for the last 28 years. The Allstate entities, as the victim of the fraud, is proactively fighting the frauds perpetrated against it by the RICO case that, when tried successfully, will take the profit out of the chiropractor's crimes of fraud, mainly because the state seems unwilling to prosecute these crimes. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you will receive notice of every blog posting, usually 5, sometimes 6 a week. And if you do, I'd appreciate it if you also tell your friends and colleagues about the blog so that they too can subscribe to the blog and to the videos on YouTube and rumble.com, all of which are free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.